Thank you all for being here this morning. I really appreciate it. How many of you went out last night? Yeah? Oh, nice. Thank you. Thank you for coming. Quite a few. I am so excited to be here today and talking with you. This is one of my absolute most favorite topics. And so I've entitled this talk, Vaccinating Ourselves Against Local Courts, because I think that that's a strategy that's applicable especially here. I do have to do one disclosure. Andreas already did it for me, but I have to tell you that nothing I'm about to say should be construed as legal advice, and I have to do that because if I don't and you take my advice and apply it and you get in trouble, I can get disbarred. So I have to say that, but basically what I'm about to tell you is how to use the current court system to help us avoid those exact same court systems. This morning I published an article on Medium about this exact topic so that you wouldn't have to try to take notes and remember links and all of that sort of stuff, and that's what the QR code is right up here, so you can feel free to take a look at that either now or later. I'm also going to try to leave plenty of time for questions. So let's get started. Our industry as a whole, particularly cryptocurrencies, is exposed to a pandemic. And I call it a pandemic because it's widespread and it's spreading exponentially. The more companies and the more people that get involved in our industry, the more exposure there is. And we don't really even know how many people and what the exposure and what the risk is. And the reason is because we have people operating in a global borderless industry that is constrained by national borders and hyper-local laws. And so we don't know what the risks are, but the good news is that there's a vaccine and it's already available, and it gives us the freedom to opt out of many of these local court processes. It's important to note that this vaccine that I'm talking about is not for criminal statutes, okay? So it's not for criminal law, it's not going to allow you to opt out of criminal court, but it will allow us to opt out of local civil courts in many, many jurisdictions. And that vaccine is called arbitration. How many of you in this room have heard of arbitration? Oh, good. So a great many of you, probably, for those of you watching video, probably 3/4. And how many of you use arbitration regularly in your contracts? That would be two. So I'm hoping to change that number after the presentation today. And I'm going to talk to you about why arbitration is awesome and why our industry should actually start adopting it as a vaccination for local courts. This arbitration has actually been used for decades by highly sophisticated multinational companies. This is something that is standard in any cross-border agreement that's drafted by any fancy law firm anywhere in the world. And I'll show you, we'll get into why that is. Part of arbitration's strength is that it is brought to us and enforceable through international treaty. And one of the primary treaties in this area is called the New York Convention on Arbitration. This map represents, the blue countries represent all of the countries who are signatories to this New York Convention treaty. And what that means for you is that every person who is within those jurisdictions, you can be protected from local courts if you use an arbitration clause. That's a really, really powerful tool, yes? So what does arbitration do and why do we care so much about it? One, it protects us from local courts. It gives us the freedom of choice. And it gives us the freedom of choice that we just don't have in traditional local courts. And I want to talk about each one of these issues individually. So substantive laws. If we include an arbitration clause, and I'll talk about what that looks like later and how to do it, but right now I want to talk about what we can actually do with this tool. You'll want to use the clause builder later, but right now let's talk about what we can do. So substantive law. What is substantive law? Substantive law is the law that we use to decide what is a breach of contract, what is negligence, what elements does someone have to prove a claim of negligence against you. In the U.S., in the jurisdictions that I'm licensed in, it would be duty, causation, breach, and damage. So you would have to prove those 4 elements. But obviously that's different in every local law and every local location. By contract, we can choose what substantive law, what body of substantive law applies. For example, we can say Delaware law from the United States applies to all these contracts, or Swiss law, or any law you choose, you can include in your arbitration clause. But legal process is more than just substantive law. There's procedural law and court rules that apply. And these procedural laws are things like, how long do you have to respond? If someone says, oh, you've wronged me, how long do you have to respond to the court? How long, how many days? Is it 5 days? Is it 10 days? How do you respond? Do you have to respond in writing through, next day air DHL? Or can you do it through email? With arbitration clauses, we can choose alternatives like email. Venue, this is another important issue. So where will the hearing be held? If you don't put anything, if you don't have an arbitration clause, for example, the Dow. Anyone who is a Dow token holder, in theory, could bring an action against the Dow in whatever area they're located in, whatever their local court system is. And whomever they could get to respond to that cause of action would then have to go to that local venue, right? So you wouldn't want me to bring suit against you, I won't. In Illinois, for example, in Chicago, right? You wouldn't want to come all the way to Chicago to defend yourself against a lawsuit. And so with an arbitration clause, we can say, the venue will be wherever you want, here, or Polis if we want to, right? But we can also say that hearings will be online. Judges, this is a really big one. So in local court systems, you don't get to pick your judge. You just get the lottery, okay? You get the court lottery. And there's no way to know, and arguably most judges don't know anything about cryptocurrency. They don't know anything about any of the things that we do. With arbitration, we can designate specific judges. You can actually name people to be judges, but you can also name specific subject matter expertise. So you can say, whoever's going to decide our dispute is going to be needs to be a subject matter expert in Bitcoin, or in SegWit, or in whatever part that you want. And that is really, really interesting, and I think a significant improvement, particularly for people in our industry, above local courts and local jurisdictions. We can choose the number of judges. So in local court, you typically get one judge. Here, you can say, we want one person to decide, but you can also say, we want 3, and we want each party to pick one, and then those 2 people will then pick a 3rd. You can separate it out in any way that you want. We have complete freedom in this area. We can choose how many people. Obviously, the more judges you select, the more costly the process will be, because those people will want to be paid. Language. Remember I said a moment ago that you can be brought into court anywhere in the world, and typically the court will use its local language, which is a big problem if you don't speak it. It then necessarily requires you to hire an attorney to do anything in that court. With arbitration, we can designate the language that the hearings and all the documents will be produced in. Duration. This is another big one. With arbitration, we can say our judges that we selected have to have a resolution for us within a certain period of time. In local court, if you've ever dealt with local court, you know that that is up to the discretion of the judge. So they may decide to render a decision immediately, but usually not. Usually they like to wait and think about it. Maybe weeks, maybe months, sometimes years in the United States. So with arbitration, we can actually put a ceiling on that. We can say that an award will be rendered in at least 6 months. Evidence. This is another area where we get to play. We can say all of the decisions will be made on paper only. So we can prevent things like a big law and order trial with, flying 10 witnesses in and getting them on the stand. If that's something that you're interested in doing, you could add that to your arbitration clause, but it's going to be pretty expensive, and I think most people in this room are not actually interested in having that sort of confrontation. Confidentiality. In local court, most of the hearings are public, at least in the United States. With arbitration, you get to decide how much and what is made public and what remains private and confidential. You can also require that an arbitration award is in writing, and that it provides reasoning. So not just a judge that says, you lose and you win, but an award that says, here are the reasons why I found it for you in this case. Here are the reasons why I found against you in this case. And that can be a powerful tool, not only to help shape your conduct later, but also in the event that you want to appeal. And appeals are another issue, and it's another thing that we can actually control with arbitration. We can set our own appeals, and we can say who we want to appeal to. If we leave it silent, then the arbitration award will stand unless it's brought to a traditional court, and I'll talk about that later. Most importantly, I think, for our industry is enforcement, and this is where arbitration gets really cool. So if you have an award from a local court, for example, in Illinois, I'm based out of Chicago, so let's say that I have an award there, and I want to come here, and I want to enforce that award against someone here. So what do I have to do? I have to go to a Czech judge and say, hey, hi, I'm from the US, there's this award that I'd like you to enforce. Will you do it? How many people think that that Czech judge is going to say, oh yes, Pamela, I'm happy to do that? Yeah, zero, right? No Czech judge is going to do that. So a local court order, a local court judgment is really only enforceable within that court's sovereign boundaries, right? Occasionally there will be agreements beyond that, but traditionally it's the local court can only reach within its boundaries. With arbitration, remember that map? Remember all of the blue countries? So that agreement actually forces courts in all of those jurisdictions to honor arbitration awards. Meaning that if the same thing happens, but I come here and I say, dear Czech judge, would you please enforce this arbitration award? And they say no, I say, yeah, accept the New York Treaty, so you kind of have to. And then they go, fine. And they actually have to enforce it. And the reason is because of international treaty. So it's actually more powerful. It's a more powerful tool than just a traditional court process. Ultimately, all of these things together mean that we have choices. We have the freedom to choose things that we otherwise would never have the freedom to choose in local court, and that's why I think that arbitration is superior. When I talk to people about this, I hear a lot of arguments against it. I think that people are like, oh yeah, I hear what you're saying, but we don't really want to be part of this system. We don't really want to be part of this whole jurisdiction thing. And so they put things on their website like, we are not subject to jurisdiction. And what that is, in my mind, is a placebo. You're taking a sugar pill and you're saying, we're not subject to jurisdiction, but in fact you actually are, and it's much worse than that. You get Arial 11. So a while back I wrote an article entitled Default Law, Arial 11. And how many of you use Google Docs? Anyone? Okay, great. And when you open up a new Google Doc, what's the font? It's Arial 11. So you can choose, if you're not a fan of Arial, you can choose Helvetica, you can go wild with Comic Sans, but if you don't make a choice, you're going to be stuck with Arial 11. This is the same thing with law in many areas, not just arbitration, in wills, in law all across the world. If you don't make a choice, you're stuck with Arial 11. And so Arial 11, the sovereign nation will gladly step in and decide what should happen if you don't make an affirmative choice. So, we can make a choice. Some people decide that the choice they're going to make is to quarantine themselves. This is how I will protect myself. I will only do transactions, fully smart contract transactions, fully escrowed with anonymous people. And if you can pull that off, good one on you. But most people can't. And the problem with that is that you're actually quarantining yourself from all of the rest of the people who can't actually make that a reality. So how do we do this? Here's the catch. You've been waiting for the catch, right? Here it is. You have to elect it in writing. You must include an arbitration election in writing. It has to be in your terms and conditions. It should be in your founders' agreements. It needs to be in basically any written contract that you have. And if you don't put your contracts in writing, you should, because this is the only way that you get this protection. There are a lot of resources online that are available to help you create these sorts of clauses and these sorts of protections for yourself. In the article that I posted on Medium, I actually have a sample of what a clause looks like using this clause builder. This is a free tool, and most importantly, you don't need to identify yourself or sign in or log in order to create it. You can play with all of the different options, and they have options for venue, and they have options for limiting evidence, and they have all sorts of what I think is fun. toys to play with. So I encourage you to take a look at that and see if something like this might actually work for you. I think it's important to note that this is not 100%, meaning that, you know, a written contract is only as strong as the paper that it's on, right? So a piece of paper will not prevent someone from going to a local court and filing a lawsuit against you. However, what it will do is it'll allow you to go to that local court and say, yeah, but we have an agreement that requires us to go to arbitration, so can you just put us into the arbitration process that we chose? And that local court will say yes. If they're in one of those blue countries, they'll say yes. So it won't prevent someone from filing a lawsuit against you because it's impossible to do that, but it will protect you once someone has done that. It will put you into the process that you've chosen. There are some really interesting side effects by adopting arbitration in a broad scale in our industry. And I think it's also important to note that some industries have adopted this so broadly that local courts don't even hear their cases anymore. They've decided as an industry that they're opting out of traditional court systems. And so every company, every person in their industry includes arbitration, and they've been able to create all sorts of innovative alternatives. You don't hear about them because they're private. That's why you don't know. One of the things that I'm most excited about is this idea of creating commercial viability for alternative systems. What do I mean by that? So in a typical arbitration clause today, you don't just say, we have a dispute, let's go to arbitration. No, it's too fast. We need a stepped process. So first you start out with, okay, we have a dispute, we'll try good faith negotiation between ourselves for a period of time. And then if that doesn't work, we'll go to mediation. And mediation is when you bring in a third party and they don't decide what's going to happen, but they help the parties come to a resolution, right? So they don't dictate what the solution will be, but they help the parties walk through, okay, what is it that you really want? What is it that you really want? Come to a solution yourselves. And only then, if that process fails, do people go to arbitration. We can do the same thing in our industry, but we can do it even more interestingly. So imagine something like, first step, good faith negotiation. Second step, mediation DAO, or crowd jury, or something like that we've created that's a community-based resolution system. And then, third step, only if that fails do we go to arbitration. We can do things like that, and the benefit of that is it actually creates commercial viability for these alternatives. It allows us to start supporting them financially once we start bringing them into contracts and using them. Remember that most people, once they get into a dispute, they go straight to the contract because they're upset, they're emotional. Most people, when we get to the point of arbitration or we get to the point of mediation, people, it's way more than just the money. It's never about the money. The money is just one component of the overall issue. Normally it's, I was wronged, I was slighted, I feel undervalued, underappreciated, this happened to me, or I have some other external cause. And so it's not simply about resolving the underlying issue, it's about all of these other things. And we can creatively find new ways to resolve those issues in our industry. And I think we're particularly positioned to find those sorts of interesting innovations. Ultimately, this means that we have the freedom of choice. We can create our own bodies of law. We can create our own bodies of procedure. We don't have to follow the existing ones. Today, we do. And the reason is because we don't have those bodies that are already developed. But part of what the DAM project is, which is, I don't know, how many of you have heard of the DAM project? Okay, good, maybe 10 of you, 15? DAM is a project from Third Key Solutions, and it's called the Decentralized Arbitration and Mediation Network. And it's an open source project intended to help explore these sorts of things, bringing arbitration to our industry and these other sorts of legal innovations. Excuse me. To end this presentation, I wanted to end it with the thing that I think is most important. And that is, I think that we have a real problem today with justice in our society. I think that right now, sovereigns and nationals can only provide justice based upon identity, and the reason is because of sovereign borders. but I feel like there's a terrible side effect, and that is that we often don't see true justice. True justice is blind, right? We see this depicted everywhere. But true justice in our systems today is not blind. It requires identity. And that has two nasty, nasty side effects. One of them is that it excludes people who don't have national identity. So an entire part of the population is excluded from traditional justice. Also, by requiring identity, it allows for bias. So if you have the right postal code, if you have the right name, if you have the right age or address, you might be treated differently from someone who has the wrong name, the wrong postal code, the wrong address. And I think that is a travesty, and I think it needs to change, and I think it can change once we uncouple identity and justice. That's my presentation. Thank you so much.
Hi, I just wanted to ask what are the areas where this is actually the arbitration applicable? As far as I understand, it's contract between two people, probably. It doesn't help me at all, I guess, in my relations to the state and like all the regulations about building code and whatever else. Is that correct?
So this is for peer-to-peer non-government contracts, although some government bodies in the United States do require arbitration, but they have their own private arbitration systems that you get to go through. So yeah, unfortunately this will not help in dealings with the state specifically. However, at least in the United States, you can opt in to arbitration if they'll agree to it. Again, this is a creature of contract, meaning that parties can generally agree to whatever they want as long as it's done with open and full disclosure and both parties understand what they're doing. Does that answer your question? I wish I had another answer.
Hi, Pamela. Thanks. This is very enlightening.
Thank you.
So which legal system is the most popular choice? And based on your experience, especially in this industry.
Yeah, that's a really great question, and I can't really give a clear answer because everyone has different reasons for choosing different jurisdictions, and this is where talking with a lawyer in your jurisdiction can really help, because there are very, very different rights that associate and obligations, rights and obligations. They never give just rights without obligations. So there's both sides in every jurisdiction. If you're a U.S. company, typically you want to choose, the laws of Delaware. Many people choose Switzerland. Many people choose Hong Kong. Many people choose Singapore. It really just depends on what your business operations are, where they intend to be. And this is another issue, just as a side note. We're in an industry of innovation, and so a lot of times people are pivoting. They have an idea here, and then all of a sudden it's not really working, and so they're doing these other things and these different things. And maybe they talked to a lawyer when their focus was here, but then they didn't when they shifted over here, and there are different rules and obligations and really risks that arise when you start to pivot. And so I would really encourage you. There are a number of lawyers in this space, and it's growing by the day, and many of them will take on pro bono clients. Pro bono means free, and or it's not really free because you count it as hours that you do as a community contribution, but free to you. So, that's an option. I wish that I could say, this is the jurisdiction for you. Ultimately, if we start to innovate in this area, we can say, okay, we're going to choose our crypto anarchist procedure, and that is this, and then we'll actually be able to choose our own set of laws. We're not there yet, but I definitely see that in the future.
Just don't pick Louisiana, because they have this weird French system of law that nobody understands, and if you get sued there, you're going to need an expert.
Yeah, that's all true. In law school, I went to law school in Detroit, and they said, this is a broad legal education, and you can go anywhere in the United States, but not Louisiana. And I was like, oh, that's good to know. Yeah.
Is there some sort of website which lists all possible arbitrations and their reputation?
There isn't really one site to go to. In the Medium article, I linked to a number of different resources. So there's, they call themselves AAA, which is the American Arbitration Association. And they have the ICDR, which is their international side, that has rules, and they have a really nice, robust website, actually. I can show you. So this is an example of a clause, and this is an example, it kind of goes off topic for just a quick second, but I do want to show you this while we can. This is an example of what a clause looks like once you've built it. Don't be scared. I know it's really long. That's what we do, we're lawyers. You know, remember, you have to say, if you don't say it, you get Arial 11. That's why it's so long, because this is attempting to deal with almost every issue that was listed in this presentation. So that's what this clause is. You know, there are a ton of other resources, and they're listed in the Medium article, which is right here. There's a ton of links, and the article actually compares traditional courts and binding arbitration clauses and step by step. So I kind of breezed through it in the presentation, but you can take a look at it there.
Thank you.
I know it's kind of a non-answer.
One question. Thank you for the presentation, very interesting.
Thank you.
Do you know which projects in the crypto space are actively using arbitration as the system? I just have seen it at the Ethereum Foundation refer to arbitration system. Do you know any other projects which are actively using it?
I know many lawyers who are trying to get their clients to use it. You know, I don't know anyone who has adopted arbitration. One of the things about this is, because it's included in the contract itself, you never really know until a dispute arises. So we have this latency, right? And the same with development, right? We get multi-sig, the protocol is approved and integrated, and then we don't see it integrated into wallets for a year or 2 years. It's the same thing here. So if we never see arbitration, hopefully that's good, because that means there are no disputes. But you know, right now, I don't know who is including this. I don't have a list of people who are including this in their terms and conditions yet.
Sorry.
Yeah.
But when it's a public project with public access, then you have to list it in your terms and conditions. Right?
Yes,
so it should be
absolutely.
public then.
Yes, it should be public. I just don't know that anyone's aggregated that information and said, okay, in our industry, who's using it? That would be a really interesting project.
Hello, thank you. I would like to ask 2 questions actually. I'm from Czech Republic, and the arbitration actually doesn't have the best name, because the agreement is always in between 2 parties, and the arbitration can be insisted only by the stronger party. And it happened that the arbiter was written like, okay, this is my former, schoolmate, and then you have to sign it, and there's no actually guarantee that the arbiter will be fair to you.
Yeah, so the question is, how do we guarantee?
Yeah.
So every nation, almost every nation, has their own national arbitration law. Again, remember, like, this is new to many of us. This has been happening for decades in sophisticated party multinational world. So the laws are robust, and most places have significant case law that talk about what is okay in arbitration and what isn't. The interesting thing is, when you're dealing within a border, you have to follow those national laws that are related to arbitration. Now, that said, I can't speak directly to Czech law, but what I can say is, the more that you include in your arbitration clause, the less you leave for the judge to decide. And then the more they have to answer to public scrutiny, right? So if you have in your contract that each party, this is one of the reasons why people choose 3 arbitrators instead of 1. Because if you choose 1, the stronger party can then exert force and try and say, oh, well, this is my friend, or this is who we always use. So that's why a lot of times people will include more than 1 arbitrator. Each party elects 1, and then those 2 elect a 3rd. You don't have to do it that way. You could have an independent third party, designate all 3 of them, or you could have an election, or you can do it any way you want. But again, if you don't say how it's going to be done, then you leave it up to discretion.
All right. You still need to be the stronger part of the contract.
I'm sorry, I can't hear you.
You still need to be the stronger one who can phrase the arbitration clause.
Yeah, so you have to have a strongly written arbitration clause, yes. So one of the problems that we see is with companies like, this has happened in the States with Airbnb, where Airbnb changed their terms and conditions and required all users to submit to arbitration, but they can take you to court, which is totally one-sided, right? And it's a reflection of the power imbalance. The arbitration itself doesn't solve those problems, but I think decentralization does. So I think that, you know, in isolation, arbitration can't solve every single problem, but as we start to move with decentralization, then we start to diffuse power structures, and then we start to create systems whereby you say, okay, I'll agree to these 3 terms, and the other party says, I'll agree to these 3 terms, and then they merge in this way, right? So I think that we can reduce the power imbalance by coupling decentralized systems with arbitration.
All right, the second question is a very short one. Can it be used in totally internet environment, like because you said it must be written, but if there's no, you know, paper exchange, no signature exchange, can it be like phrased on my terms of service or you know, used arbitration in that way?
Yes, as long as the local jurisdiction acknowledges or recognizes terms and conditions, which at this point in national and international law is pretty well set. It should be binding as long as you include it conspicuously, right? The thing is you can't bury it somewhere and be like, oh yeah, on the 18th page we're agreeing to arbitration and things like that. You know, like the local court is probably going to say, no, that's not really an open agreement. And remember, this is taking power specifically from the court that you are going in front of, right? How this actually plays out is someone goes to court, I go to court in Chicago and I say, Your Honor, this person has wronged me. And then you come in and you go, no, court, you don't have jurisdiction based upon this terms and conditions. Do you see what I'm saying? So you need to make sure that you have law that supports that. And in the United States you do, and in most jurisdictions, you know, UK, almost all of Europe has pretty strong precedent that says that the local courts must do this. Of course, there's always exceptions, but yeah, I mean, you do need to have it in terms and conditions. You do need to have people agree to this in writing. That's the catch.
Thank you for your talk. I was wondering if this relates primarily to services or if it can relate also to, for example, Creative Commons licensing of, I don't know, writing, photography, and things like that.
Good question. Yes, it's my understanding that it applies to everything. Yeah, go ahead.
I use it in the licensing of my content. I have an arbitration clause both for my conferences and for my Creative Commons licensed content, and if there is a dispute about the licensing of my content, I take it to arbitration. Yes, you can. My contract itself is Creative Commons. Of course. Next.
First, thank you very much for the talk. It was very refreshing to hear one where you had to actually pay attention to every word said. And that was not because of the language, but because of the payload.
Oh,
and
good. Yay.
The question is kind of a follow-up question to the question about countries, which ones get picked. Is it possible to write arbitration clauses, or I don't know what they're called, I'm not a lawyer at all, and include them in contract in so much detail that it actually doesn't matter which country you picked? Or what is the granularity typically of these clauses or whatnot? Does it make sense at all? I don't know, I'm not a lawyer, but...
Yeah, no, that's actually a really great question. So a lot of controversy that we've heard about arbitration is that in the US, people say, well, arbitration isn't that great because, you know, it's actually, it can take as long as local court and it can be as cumbersome and all of these things. And the reason for that is because in the US, most of the time, the lawyers who write contracts are not the same lawyers that go to court. And so the lawyers that write contracts say, oh, we should have arbitration. Okay, we submit everything to binding arbitration. Boom, and it's like 2 sentences. Remember that clause I just showed you, how long it was? So you have to have that sort of detail in order to constrain the court. Remember that the court will gladly substitute anything that you have not added. So to follow on your question, can we write these clauses in such detail that we effectively, we effectively control every aspect of the system? I think yes-ish. I'm just totally hedging. I think yes, but I don't know what that looks like yet because it's such a big project, right? And I think that I'm also really interested in how these other legal innovations can help us solve problems before we get to arbitration. But yeah, I think default, like the more detail you put into your arbitration, I think one of the most interesting things is to develop our own substantive law. Now, whether or not that will work, that's really open to debate. But if we can develop our own substantive law and say, this is the law of this community, and some of the other speakers so far have been talking about that, this is a way to use that and to actually integrate this into legally enforceable contracts. So we can say, we adopt the law of this community, and that community law is what will govern this dispute. The issue with doing that is that traditional laws have evolved over hundreds of years, and it's almost impossible to write a law that will cover every single scenario. Remember, if the law doesn't cover every single scenario, then the local court law will happily fill in. So we have to create a system that, we can adopt the law of this community, and for things that aren't addressed, we will take the law of this standard body of laws. Does that make sense? You're welcome.
Good morning. Thank you, Pamela, for coming and talking about all these things. It's really exciting and wonderful. On the question of transitioning from purely cyberspace to our 3D reality and back, perhaps, we have alluded to the notion of, well, the local governments, or not governments, the local jurisdictions must recognize the identities, right? How about, or has there been any work done on selecting a proxies as in representatives? Let's say I'm John Doe in cyberspace, and in my clause I say I will not reveal my real identity. I'm doing stuff in that cyberspace, but I choose Pamela as my representative here on Earth. What issue would then the law, the actual enforceable 3D law, would have with that setup?
Really great question. I don't think that I have a clear answer for that. What I will tell you is that often parties in the traditional world will have an attorney represent them as their agent. And what you're effectively talking about is an agent relationship. So you're saying, I'm not going to appear, but I'm going to send this person to appear on my behalf.
Well, essentially, I'm saying I'm not going to disclose who I am.
Right.
But I am sending a representative who is agreed to me. The representative doesn't know my identity, but the representative is willing to address on my behalf the court.
So I think you're not going to find much success with that in traditional courts, and the reason is because traditional courts like to have the enforcement side. So if I'm coming and I'm representing as your agent, but I can't actually make you do anything, then it's effectively negotiating or having a judgment upon nothing, right? However, that doesn't mean that we can't do that in our own systems. If you can find someone that can contract with you and that agrees that, okay, this person can remain anonymous, we can negotiate through this third-party proxy, and we can have a way to still make good on whatever promises are made with this third party, then there's no reason not to accept it.
Thank you.
You're welcome.
Hi, thanks for your talk. I just want to take a step back and clarify something. So arbitration rules apply to every case in civil law, or you also pass potentially between private entities, or does there have to be a legal entity and a private and a natural person? And also, do the parties have to come from different jurisdictions, or could I, for example, agree in a rental contract with my landlord who lives next door on an arbitration clause?
Yes, you can agree on a hyper-local level that you're going to deal in arbitration. we may end up with the same situation that our friend over here mentioned, which is your local court may decide that that isn't enforceable for whatever reason, and so you may have some hurdles. What I talked about today was specifically targeted to international and cross-border. But again, underlying all of those international and cross-border agreements are national laws. So in whatever country you're operating in, you would need to know what the arbitration rules were as far as that goes. Now, back up for a second. If you select your own rules, then you get to go with those rules. It's only if you leave it blank, only if you use the default law, that the national rule set will step in. Does that make sense? And what was the other part of your question?
Is it between natural persons, corporations, fictions, legal fictions? What are who can be the parties?
Oh, we in the law have no problem with legal fiction. We love it. We create it all over the place. We'll recognize it, no problem. Again, the real underlying issue is enforceability. So if you create a corporation, or you attempt to create a corporation and you didn't do it properly according to process, it doesn't mean that there's nothing. What it means is you have individuals behind it, and those individuals are responsible, right? So you can name, anyone can be a party to arbitration, just as anyone can be a party to a traditional court process.
Thank you for your presentation. I have two questions. First, what are the limits of court revision of arbitration decisions in the United States? Because another problem we face in the Czech Republic and Czech arbitration is that quite often Czech courts decides that there was some procedural mistake. Often can be something very minor, but they decide, and they just, it takes another 2-3 years at the court after arbitration. That means it could be 5 years altogether.
Yeah.
And the second question, is there any possibility in the United States for the judge, for the arbitrator, to take some kind of attorney general, or amici curiae, as we call it, especially, when you have some complicated dispute, for example, technologies, and probably there will be no judge who understands the topic. So if he has legal possibility to ask a professional, trained person who is deeply concerned in the topic to help him with those technological things or professional things that he doesn't understand. Thank you.
Yes, I'll take the second one first, and then you might have to remind me of the first one. So the second one is really experts. And so yes, in the United States, often experts are brought in to help educate the court and or the jury on technical issues. And so this is quite common. Sometimes you get into the battle of the experts, where attorneys from both sides will have competing experts that will say one thing and the other thing, and I don't know how beneficial or clarifying that is, but that's the situation that often happens. One of the things you can do by contract is agree that you will have one joint expert and set their qualifications, and you can do that also in arbitration, but you can do that also in other systems like I just spoke today about arbitration and briefly about mediation, but this is part of a larger body called ADR, or Alternative Dispute Resolution. And one other component of that is called collaborative law. And those sorts of agreements are very common in collaborative law. And the point of collaborative law is to have people come to agreement amongst themselves. And so they'll often take an expert for business valuation purposes or something like that and say, okay, we both agree that whatever this expert says, we're going to agree with, and this is how we're going to decide the case.
The first part of the question was about the process of appeal to higher authorities and whether that process can be used to override the arbitration results and cause problems because of procedural errors.
Great question. One of the most important things you can remember in doing arbitration is due process of law. That is one of the main reasons why arbitration awards get overturned, because people must have the ability to participate in due process of law, meaning that you can't say, our arbitration is going to take 48 hours. because there's not enough time to actually, allow people to create their case. There's not enough time to have people think about what their defenses might be, or amass evidence that they can prove that, okay, I'm right. So if you had something like that, if you had a procedure like that, that would certainly be overturned by a local court. Generally, though, there are very narrow grounds, and they're highlighted in the New York Treaty and elsewhere. I'm happy to provide them if you want, but there's a whole list of maybe 5 or 10 things that are red flags. If you do these things, then you'll probably get overturned. Otherwise, if it's not part of that, the default is we don't look at arbitration awards. The default is, unless there's a procedural issue, we don't open arbitration awards. What does that mean? That means that if it's unfair, they don't care. They're not going to open it. That's not a legitimate reason to look at the arbitration award. I briefly talked about appeals process. And so with the standard arbitration, at least in the United States, there is really no appeal. The only appeal you can do is to a local court and say, okay, the process was flawed, I didn't get my due process. However, we don't have to do that. You can add an appeals process if you want, an arbitration appeals process that broadens, and we can create those and what that looks like ourselves. In the sample clause that I included, there is an appeals process for arbitration, and it talks about what that might look like.
Would you be able to design this alternative mediation process in a way to avoid completely to go to the final step of a judge or whatever, in a way that, for instance, you add the need for both parties need to put up some deposit, and then by whatever means, like voting on a distributed judge system, so it will be decided where the deposit goes, and there is no way that two parties can argue further to this point?
In theory, yes. In practice, no. Yes, you could have, well, first of all, I'm not going to create that. The whole point is I want everyone else to start getting excited about legal innovation. We don't want to create a company that is like the arbitration company. What we want to do is help other people create commercially viable alternatives like what you're talking about. Now, if you had an escrowed system where the money was automatically transferred at the end, right? Okay, done. Now what happens if I'm unhappy? What do I do? There you go. I sue the other party. That's exactly what happens. And so when I go to sue the other party, what happens? One of two things. A, we have no arbitration clause, and now you're coming into local court, wherever I am, upon whatever rules that are of the local court, and now you have to defend yourself, and we're back in the mess. Or you do have an arbitration clause, and I still bring you to local court, but you say, get out of local court free card. Here it is, I have my arbitration clause, and then that judge takes you back into the final arbitration. That's why the arbitration is the last step. How are we doing on time?
We have time for one more question.
Okay.
Does anybody have a question? Or yes, sorry, behind me.
Thank you. As far as I understand it, and correct me if I'm wrong, you cannot use arbitration for like labor law, or like, because the minimum wage is mandated by the federation and by the state. Do you have any plan to increase the scope where you can have arbitration clauses, or is that out of your project?
I wish that we could superimpose our will on national law, but unfortunately, my friend, that is not really in the wheelhouse for right now. That said, you can by contract. So here's the other thing about contracts. They're paper, usually. I mean, sometimes they're pages online, but you can write anything you want in them, right? It doesn't mean that it's legal. Doesn't mean that it's actually right. We see this in rental agreements all the time, where landlords write things like, you can never have guests. Well, no, you actually can. Local law provides that you can have guests, and that will override any sort of contractual agreement as a recognition that the parties have a power imbalance. So you can write anything you want. in the contract, and you can agree, obviously you should, for community's sake, agree to a fair wage. But if there are disputes, actually in the United States, labor disputes are often heard in arbitration. They're often heard outside of traditional courts.
Would it be possible to hide information from local courts about what actually the contract is about? In a way, for example, that write public clause which says that everything must be arbitrated by some concrete arbitrator, and the contract would be revealed to him, and there would be just hash of the contract in that clause. So you could theoretically hide the information from local court. Is that possible?
I think what you're asking me is, can you not make the full contract public or the underlying issues public, but say the hash of this contract is subject to arbitration? Is that what you're saying? Absolutely. As long as you can get the parties to agree, and this is the issue. So I don't think, in my mind, it's not sufficient to say, to put up a web page that says the hash of all of these contracts are subject to arbitration. And the reason is because you don't have proof of agreement. You have one party saying, we're going to arbitrate, but you don't have assent, you don't have consent from the other party. So that's why you would have to include it in a terms and conditions sort of document or something like that, that actually has the parties consenting. You could also very simply put a little checkbox that says, I agree to arbitration. Like, it doesn't have to be this whole like big deal. It just has to be clear. The person who's agreeing to give up their rights, and believe it or not, the courts believe that this is a sacred right that you have to avail yourself of their, good judgment. And so if you're going to give that right away, you have to do it knowingly. And that's a protection, it's a consumer protection.
I think what you just described is a new thing which we'll have to call Merkelized abstract contract trees, where you reveal the arbitration clause and the Merkel path that leads to the root of the contract and a digital signature.
Yes.
Excellent. That's it. We have time for today. Please thank our speaker, Pamela Morgan. Thank you.
Thank you.